The business of medicine is constantly changing. The review by Resolve discusses current contract issues for physicians, compensation trends, and tips for a successful career. Every physician's contract and career is different, and nothing in this episode should be considered legal advice. If you have specific questions about your career, please consult with an attorney. Now, on to the show.
Okay, welcome back to the review. We are here today with a friend of ours, Angela Lopez. We did an episode previously on J-1 waivers, and I had a lot more questions, and so we brought Angela back. She's an immigration attorney that works specifically with physicians. So, Angela, thank you for being back on.
Thank you, Kyle. Please, happy to be here.
Awesome. Well, one of the things we talked about last time was the importance around timing. And, kind of what the actual application process is for a physician who's on a J-1 visa, who's then going through the waiver process. Can you kind of jump back to that and just recap for us? When should they be starting this process? Like when is too early? When is too late? Kind of give us that timeline.
Yes. It's never too early. I always tell people the sooner you understand the process, the better off in terms of planning how you're going to go about finding that employer that is going to sponsor your waiver and filing the waiver timely. Okay, so never too early. Too late, never too late, in terms that if you don't mind going back home for a couple months or some time before you can come back and an H-1B after your J-1 waiver is approved, well, then it may not be too late. However, the general rule of thumb, what I tell my clients is you want to start working and finding the employer or that is going to sponsor your J-1 waiver somewhere between 14 to 18 months before your last year of residency or fellowship. You want to have an employment contract finalized, maybe not signed, but at least finalized before the end of your second year of residency or your first year of fellowship. Because J-1 waivers, the cycle to apply for J-1 waivers starts on October 1st. And what the ideal situation is that we start working with the physician sometime early in the year, maybe May, April, even March, no later than June or July of the given year, we'll file in the waiver, because I like to file my waivers on the first available date. So if the first date the agency is taking waivers is October 1st, I want my waiver on October 1st there. There's also some states are more competitive than others, so they fill up waivers slots very quickly. A couple of them are New York, Illinois, Massachusetts, California, Texas, where I'm sitting. So you really want to file your waiver as soon as possible. Many of those states are first come, first serve. So you want to have that petition ready for filing. That means you can't wait to the last minute to get the employer, get the contract, start working on the petition and file it timely. So those would be like my main tips for people to plan a smooth and hassle-free waiver processes.
Yeah, so if you're a physician on a J-1 visa, you need to be looking at an employment contract as soon as possible, right in your last year of training, whether that's last year of residency or last year of fellowship, because getting that application in timely can make or break whether or not you're selected. Is that what you're telling us?
And that's correct, and that's key, because one of the main elements or components of the waiver is the employment contract. And I know I work very closely with you, Kyle, and I love it because you're my, like, the first one. You need somebody to talk about your contract. Here it is. I do review contracts, but only for J-1 waiver compliance. So I want to make sure that the employment contract is for full 3 years. And it starts on whatever date and it's full 3 years. That it has the basic language of the agency's requirement, which is the physician will work full time, whether it's 40 hours or 160 hours per month, 40 hours weekly or 160 per month. That there's non-compete clauses, that's not allowed. And so other couple clauses, I do the review for that, make sure it is included in the contract. Everything else, I just send them your way, Kyle, to advance another
we do the same thing. So we always tell people we're not filing the waiver. So there's slight differences if you're a Conrad program versus an HHS, where the contract language might be a little bit different and the requirements there. So we always say, whoever's going to process your waiver, you ought to be having them look at this. And sometimes we'll see a specific addendum or an amendment that covers kind of the immigration components.
And very frequently, that's what is done, an amendment to the contract, so all the terms are covered, because the agencies will return the waiver, or they might get back to you saying, hey, this contract is missing this, and that, or you need to delete this, and that. So it's better to get it done from the beginning.
Yeah. So you mentioned the competitiveness of the Conrad program, or any program, right, in some of these states like California, Texas. I know that there's alternatives to the normal IGA waivers, hardship, persecution. Can you talk about those?
Okay, the hardship and persecution. Those are, in my book, and what I tell people is that those might be the last resource, but if you qualify for one of them, don't dismiss it. And the way we go about that is you might qualify for exceptional hardship. And the key for hardship is exceptional hardship, exceptional as opposed to extenuating hardship. What is the difference? For exceptional hardship, you need to demonstrate that you have to stay in the United States. You can't go back home for 2 years. You can't. And for that, you have to have a qualifying relative that is going to suffer if you're going back for 2 years to your home country, or if they go with you for those 2 years to your home country. Qualifying relatives are U.S. citizen or U.S. permanent residents, spouses, maybe. So if you have, and we do process those waivers, but they take forever. Right now, the average processing time for the Department of Immigration to process hardship waivers is about 18 to 20 months.
Wow.
So frequently what we do with the exceptional hardship waivers is, yes, we will process your hardship waiver, but then when time comes, we need to process your IGA, Intergovernment Agency waiver, because the first one that is approved, that's the one you're going to go with.
So that's the question I've always had, Angela. Can you have two different waivers going at the same time, or two different applications?
Only if it is a persecution or a hardship waiver, along with an IGA, the Intergovernment. But you can have two Intergovernment waivers going on at the same time. That's not allowed. You can only process one at a time.
Yeah, so like Conrad and HHS, I can't do both of those at the same time.
No.
But if I do have a hardship, kind of component, I can also have a Conrad. That's really good. I didn't know that.
Yes, okay. that can be done. Now, that's a hardship. So some of the grounds for a hardship, and we've done some of that, and not the best situations, but we have done it. For example, I work frequently with a family of physicians. Husband and wife are physicians. They're both subjects to the J-1, and they have a small child, U.S. citizen. And in some of those cases, if the child has a condition that requires medical attention, and the medical attention is in the United States, and one of the parents have to be the primary care or take care, or then having the other parent living might be a hardship to that child.
Sure.
Other hardships are not many there, but you have to demonstrate is that it would be detrimental to the U.S. citizen if that person leaves. Now, for persecution, those are very specific waivers, and the grounds for the persecution waivers are similar to the asylum waivers.
Okay.
Waivers to the asylum. There's no such thing as asylum waiver. The asylum, because it's based on persecution in your home country. If you have to go back for 2 years, you're going to be exposed to persecution by race, religion, or political opinion. And it has to be well documented that if you go back, your safety is at risk because of, and you have to demonstrate what. These persecution waivers take as long or even longer than the hardship waivers. We were talking about that the other day at one of the seminars I attended, and right now they're up to about 22 to 24 months for persecution waivers.
Wow.
So then you do the persecution, but also keep your options open with an IGA waiver.
Yeah, so I guess there's probably no hard data point on this, but in your practice, what is the percentage of physicians that are utilizing hardship or persecution versus IGA?
I don't have that data, honestly, but it's not significant.
Yeah. The
Because
majority is IGA.
I'm sorry?
The majority is IGA?
Yes, because the problem with those waivers, the hardship and the persecution, is the processing times. Physicians can't sit on a process for 2 years waiting for a result, and if it is not approved, then they may not have time to do an IGA.
Yeah.
So it gets complicated if you're only going with one of these two waivers, because you might need to leave the country if things don't work out the way expected, and then find another way of obtaining a waiver.
Yeah. It seems like you'd almost have to start the application as soon as you get into residency, right? Because it's going to take 2 years to find out the answer. So, okay. Well, that's really good advice. There's, competitiveness we talked about for the Conrad program. We've talked about the different types of waivers that are out there. I've got more questions for you on location specific things, right? And like HPSA scores. And I think there's a lot of confusion around that. So we're going to do that on another episode. I'm going to have to come back a third time. But I appreciate you being on today, and we'll chat again. Okay.
All right. Thank you so much, Kyle.
Thanks. Bye-bye.